This hearing will come to order. Good morning, everybody. I want to welcome our witnesses, say how much I appreciate your thoughtful testimony. I've read it all. There's some pretty compelling stories. This is, from my standpoint, a very important hearing. As I've looked back at the laws written, designed to protect people that have the courage to come forward within government, to blow the whistle, to tell the truth, to highlight problems of waste and abuse and corruption and potential criminal activity within departments and agencies. We have a number of laws, and they date back quite a few years. And with Mr. Devine's testimony, I added a new one. I didn't realize it went back as far as 1912 with the Lloyd LaFollette Act, followed by the Civil Service Reform Act of 1978, then the Whistleblower Protection Act of 1989, and then the Whistleblower Protection Enhancement Act of 2012. And yet we still have problems. My own experience with this, having come to government pretty late in life, started really with the events with Secret Service in Cartagena. And then as we started looking at the reports being issued and written by the Office of Inspector General, the fact that there was retaliation, or certainly evidence of retaliation against members of that inspection team for being forthright. And then followed up just recently with our border security hearings, we had a Customs and Border Protection agent, Chris Cabrera, testify before this committee, contradicting some of the information from the Department of Homeland Security, but also testifying under oath, as all of you will be doing here today. And a few weeks later, a couple months later, he testified on March 17th, 2015. A few months later, right before another hearing on May 13th, 2015, this committee was made aware that Agent Cabrera was being scheduled for a hearing in front of the Internal Affairs. Now, I raised the issue with then Deputy Chief of U.S. Border Patrol, Ron Vitello, and I stated, because of my Lutheran background, I'll put the best construction on things, and I was assuming that hearing with Internal Affairs was all about being concerned about what he was bringing to the table and wanting to correct any errors within the Customs and Border Protection Agency. I'm not so sure that was the case. Fortunately, because we highlighted in our hearing that that Internal Affairs hearing with Mr. Cabrera was canceled that same day rather abruptly. So I've a certain sense that maybe that wasn't so innocent. They really had something else in mind with that hearing. So these issues are very serious. As a result, my office has set up a website, Whistleblower at ronjohnson.senate.gov. We've already had over 130 whistleblowers throughout the government contact our office, and what we have here today are 4 of the individuals that did contact our office. And I'm also mindful through Mr. Devine's testimony that probably the greatest risk any whistleblower incurs is when they contact Congress. It sounds like that is where the greatest retaliation can occur. So again, I want to thank all the witnesses for coming here. The purpose of this hearing is not to adjudicate the issues you have raised. I mean, that will occur through a process, a procedure. The purpose of this hearing is to highlight, so the American people understand, so that this committee understands, that once an individual steps forward and puts their career at risk, expose themselves to the type of retaliation that is unfortunately all too common. We want to hear what type of retaliation is inflicted on individuals and what form of retaliation or what forms retaliation takes. So that's really the purpose of this hearing. I do want to caution people there may be some areas where some testimony might come close to revealing classified information or law enforcement sensitive. I want to make sure we don't breach those restrictions. But with that, again, I want to welcome all of our witnesses, appreciate your courage, appreciate the courage of anybody willing to step forward and risk that kind of retaliation. And I'm looking forward to hearing your testimony and your answers to our questions. With that, Senator Carper.
Thanks, Mr. Chairman. It's a pleasure to meet all of you and to welcome you here today. Thank you for your service in different arenas, and particularly those of you who serve in uniform and who have served in uniform of our country in the past. Mr. Chairman, I appreciate your efforts to highlight the retaliation that too many of our federal employees have faced over the years, even today. And when they've blown the whistle on waste, blown the whistle on fraud, on abuse and misbehavior within their agencies. You've heard me often talk about how invaluable the work is of the Inspector Generals across our government, the General Accountability Office and others are to this agency and to this committee as we work together to get better results for less money and reduce our federal debt, continue to reduce our federal debt. I'm reminded today that many times it's actually federal employees and contractors within the government that first draw attention to issues or wrongdoings in their agencies. They are just as invital and just as vital a part of our team as we work together to make this government of ours even better. Without people who are willing to stand up and say something is wrong when they see that it's wrong, it would be much harder to root out waste, root out fraud and abuse. And in order to encourage people to stand up, we need to ensure that when they do, they'll not be punished for doing so. I have been a long-time proponent of strengthening agency oversight by hearing from and protecting federal whistleblowers. A few years ago, a whistleblower from the Dover Air Force Base within my state contacted my Dover office with information about mismanagement at base mortuary. It's the Air Force mortuary, and it's actually the mortuary for our country, where we bring home the remains of our fallen heroes. My office was able to draw attention to both of these issues and the retaliation that the whistleblower, in fact the whistleblowers, were facing. At the end of the day, the Office of Special Counsel, and their investigation led to disciplinary action not against the whistleblowers, but against several people in leadership positions at the base within the mortuary itself, their top officer at the mortuary, colonel, to the reinstatement of whistleblowers and others there. I was struck by the courage of these brave whistleblowers who risk so much to right or wrong. To be honest with you, I was also struck by the good work done by the Office of Special Counsel, whose responsibilities include looking out for the whistleblowers and making sure they get a fair shake, as well as the taxpayers. This committee as a whole also has a strong history of working with individual whistleblowers to root out waste, fraud, and abuse. For example, in our last Congress, testimony from whistleblowers was critical to a hearing and investigation led by former Senator Tom Coburn, former Senator Carl Levin, into an administrative law judge office in West Virginia, which is responsible for reviewing thousands of applications for Social Security disability programs. That hearing, I'm sure you recall it, Mr. Chairman, that hearing was powerful and proved critical to improving accountability and oversight in the disability program. These whistleblowers performed an important role in both the investigation and in the hearing. There's a number of women, very brave, courageous women, really to put everything on the line, their jobs, their livelihood, their lives, in order to be able to tell us the truth. And without them, there would have been no investigation, there would have been no hearing, and the fraud the committee is shining the light on may have never been uncovered. So I believe in whistleblowers, and I'm grateful for whistleblowers and think that we need to be treated, golden rule, make sure they're treated like we would want to be treated if they're in their place. Those are just two recent examples of the critical role that whistleblowers can play. I was pleased to learn in preparing for this hearing that the Office of Special Counsel has made significant progress in the last couple of years under the leadership of Special Counsel Carolyn Lerner in protecting whistleblowers. In fact, I've been told that favorable outcomes for whistleblowers that came to the Office of Special Counsel have increased since 2007, not just by 100%, not by 200%, not by 300%, not by 400%, not by 500%, but by 600%. It's a huge turnaround and a great improvement. That's an impressive statistic, but Congress and the administration have additional work to do to better ensure that individuals feel free to speak out without fear of retaliation. In fact, we passed the most recent law, I think 3 years ago, in 2012. I was happy to support that legislation to further strengthen the role of the Special Counsel to enable them to encourage whistleblowers to muster the courage and make sure when they do that they're not retaliated against. Before we go any further, though, I would be remiss if I didn't also note, as the chairman already has, that the whistleblowers here today have retaliation claims that have not yet been fully substantiated in cases that are still pending. Having said that, on the one hand, I'm glad that we have the opportunity to hear from all of you. We welcome you today. But to be honest, I have some concerns about publicly discussing cases that involve ongoing investigations and litigation. Congress has established, as you know, paths for whistleblowers to obtain independent, objective reviews of their complaints. They can do this through the Office of Special Counsel, as we've done in my own state at the Dover Air Force Base, the Merit System Protection Board, the Offices of Inspector Generals, and the federal courts. And I hope that today's hearing is not seen as interfering with or somehow prejudging the reviews relating to our witnesses' claims that are underway today. I'd also note that there's some perspectives on the issues that our witnesses raised that we will not hear today. Perspectives that would help us better understand these issues. And I hope that as we continue our oversight on this subject, and I hope we will, we'll have the opportunity to hear from the agencies involved, especially from the Office of Special Counsel. That said, I nonetheless hope that we can learn some valuable lessons here today about the experiences that our whistleblowers face, what we can do to better support them, and how we can improve both the climate and the process for which whistleblowers in the future. And again, I appreciate the hearing, Mr. Chairman, especially pleased to join you as a member of the newly created Senate Whistleblower Caucus. We look forward to working on these and other important issues. Thank you.
Thank you, Senator Carper, and I can assure you this is just the first step. This is the first hearing. Again, the purpose is to highlight the form of retaliation and what happens, and we will continue to delve into the subject with probably multiple hearings. With that, it is the tradition of this committee to swear in witnesses, so if you could all rise and raise your right hand. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. Our first witness is Lieutenant Colonel Jason Amerine. Lieutenant Colonel Amerine serves in the United States Army and led a Special Forces team in Afghanistan in 2001, for which he received a Purple Heart and Bronze Star with V device, which denotes participation in acts of heroism involving conflict with an armed enemy. Lieutenant Colonel Amerine has raised concerns about hostage recovery efforts to Congress. Lieutenant Colonel Amerine.
Thank you, sir. Warren Weinstein is dead. Colin Rutherford, Josh Boyle, Caitlin Coleman, and the child she bore in captivity remain hostages in Pakistan. I used every resource available, but I failed them. One of those resources was my constitutional right to speak to members of Congress. You passed the Military Whistleblower Protection Act to ensure such access. But after I made protected disclosures to Congress, the Army suspended my clearance, removed me from my job, and sought to court-martial me. As a soldier, I support and defend the Constitution of the United States in order to have a government in which the voices of the people are heard. My team had a difficult mission, and I used all legal means available to recover the hostages. You, the Congress, were my last resort. But now I'm labeled a whistleblower, a term that's both radioactive and derogatory. I'm before you because I did my duty, and you need to ensure all in uniform could go on doing their duty without fear of reprisal. Let me be clear. I never blame my situation on the White House. My loyalty is to my Commander-in-Chief as I support and defend the Constitution. Whatever I say today is not as a Republican or a Democrat, but as a soldier without allegiance to any political parties. In early 2013, my office was asked to help get Sergeant Bergdahl home. We audited the recovery effort and determined that the reason the effort failed for 4 years was because our nation lacked an organization that can synchronize the efforts of all our government agencies to get our hostages home. We also realized that there were civilian hostages in Pakistan that nobody was trying to free, so we added them to our mission. I assessed that both issues were caused by an evolutionary misstep that created stovepipes of our federal agencies. The Department of Defense faced this problem in the 80s as Army, Navy, Air Force, and Marines operated independently of one another, leading to the Goldwater-Nichols Act of 1986. Transformation on that scale literally takes an act of Congress. To get the hostages home, my team worked 3 lines of effort. fix the coordination of the recovery, develop a viable trade, and get the Taliban back to the negotiating table. My team was equipped to address the latter two of those tasks, but fixing the government's interagency process was obviously beyond our capability. Recovering Sergeant Bergdahl was a critical step to carrying out our Commander-in-Chief's objective of ending the longest war in American history. So I went to Congress in order to repair a dysfunctional bureaucracy to support our president. It caused the Army to place me under criminal investigation. I spoke to Representative Duncan Hunter because he's a member of the House Armed Services Committee. I needed him to buttress our efforts with two simple messages. The hostage recovery effort was broken, and because of that, 5 hostages and a prisoner of war had little hope of escaping Pakistan. It started to work. His dialogue with the Department of Defense led quickly to the appointment of Deputy Undersecretary of Defense for Policy Lumpkin as a hostage recovery coordinator for the Pentagon. This step enabled the DoD to act decisively on the Bergdahl trade once the Taliban sought a deal. But the civilian hostages were forgotten during negotiations. I continued to work with Representative Hunter to try to get them home. He set up a meeting between my office and the FBI. Then the FBI formally complained to the Army that information I was sharing with them was classified. It was not. The Department of Defense Inspector General has since reviewed the information through my DoD IG complaint and confirmed it was not classified through a joint staff review. But still I'm under investigation. A terrible irony, a horrible irony, is that my security clearance was suspended on January 15th, the day after Warren Weinstein was killed. We were the only effort trying to free all the civilian hostages in Pakistan, and the FBI succeeded in ending our efforts the day after a U.S. drone strike killed Warren Weinstein. Am I right? Is the system broken? Layers upon layers of bureaucracy hid the extent of our failure from our leaders. I believe we all failed the Commander-in-Chief by not getting critical advice to him. I believe we all failed the Secretary of Defense, who likely never knew the extent of the interagency dysfunction. But now I'm considered a whistleblower for raising these issues. There's been no transparency to the Army's investigation of my protected communications with Representative Hunter. The Army would not even confirm why I was being investigated for the last 5 months until this week, and they only did that because of today's hearing. Danielle Bryan and Mandy Smithberger of the Project on Government Oversight have been a godsend, and Representatives Duncan Hunter and Jackie Spear stood up for me where nobody else in Congress did until today. I'm truly grateful for the opportunity to testify before you. The outpouring of support from fellow service members has been humbling. Worst for me is that the cadets I taught at West Point, now officers rising in the ranks, are reaching out to me to see if I'm okay. I fear for their safety when they go to war, and now they fear for my safety in Washington. Is that the enduring message we want to send? And we must not forget, Warren Weinstein is dead, while Colin Rutherford, Josh Boyle, Caitlin Coleman, and her child remain hostages. Who's fighting for them? Thank you.
Thank you, Lieutenant Colonel. Thank you for your service to this nation. I will point out that Representative Hunter's in the audience here, so welcome, sir. Our next witness is Ms. Taylor Johnson. Ms. Johnson is a senior special agent with Homeland Security Investigations, a component under Immigration and Customs Enforcement. Special Agent Johnson has raised concerns about national security and criminal risks in the EB-5 program to her management and to the DHS Office of Inspector General. Ms. Johnson.
Chairman Johnson, it seems we're all going to do that today. Chairman Johnson, Ranking Member Carpenter, and distinguished members of the committee, I appreciate the opportunity to speak before you guys today surrounding the issues of and obstacles with whistleblowing. I am a special agent. I've been with HSI for about 11 years. I've been responsible for investigating large transnational organized crime groups involved in money laundering, narcotics, and bulk cash smuggling. I won't bore the committee with any awards of accommodations, although I have received some of the highest honors of our department, and my OPM file reflects clearly our yearly promotions. After disclosing gross mismanagement, waste, and fraud that threaten general public safety, national security risk, and public corruption surrounding the EB-5 project, I was subjected to a significant amount of harassment and retaliation. With the approval of my chain of command, I began investigating the EB-5 Regional Center and a U.S. investor. Some of the violations investigated surrounding the project included Title 18 statutes of major fraud, money laundering, bank and wire fraud. In addition, I discovered ties to organized crime and high-ranking officials and politicians who had received large campaign contributions and promotions that appeared to have facilitated the program. I disclosed this to my management and later the Office of Inspector General, specific examples of national security risk associated with the EB-5 and the project under investigation. Some of those security risks coincided with what the CIA, the FBI, and the SEC have already discovered as well. During the course of the investigation, I discovered that EB-5 applicants from China, Russia, Pakistan, Malaysia had been approved in as little as 16 days. The files lacked the basic and necessary law enforcement queries, and that was evident by the regional centers, SOFs, and applicants' 526s. I found over 800 operational EB-5 regional centers throughout the U.S. This was a disturbing number for me since the U.S. only allows 10,000 applications per year. I could not identify how CIS was holding each regional center accountable or how they were tracked once they were inside the U.S. In addition, a complete and detailed account of the funds that went into the EB-5 project was never completed or produced after several requests related to that investigation. It became evident that there were some serious and significant national security risks to that program. From the onset of the investigation, my management began getting complaints from outside agencies and high-ranking officials. As a result, I was removed from the investigation, and it was ultimately shut down and closed. Shortly after, I was escorted by 3 supervisors from my desk and out of my permanent duty station. I was not permitted to access my case files or personal items. I was removed initially over 50 miles in direct violation of Title V. My weapon and credentials were taken against the agency's firearms policy. My government vehicle was confiscated. Access to the building and all government databases was revoked. I was told I couldn't even carry or own a personal weapon, which is a constitutional rights violation. I've been placed on AWOL on 6 separate occasions, 4 of which were during my meetings and interviews with OIG and the OSC. When an adoption social worker tried to contact and verify employment, she was told that I'd been terminated for a criminal offense. I almost lost my 1-year-old child. I report to a building that houses inmates where parolees report and in an area that has the highest homicide and transient population in the U.S. I am continuously placed in dangerous situations with no way to protect myself or others. Management has willfully obstructed me from competing for any promotions and injured my prospects to promote. Lastly, after being contacted by the Office of the Inspector General on the EB-5 case and designated as a witness, the agency falsely accused me of misconduct during a border enforcement operation in 2011. The result of the it resulted in termination recommendation. The allegations surrounding the termination have since been proven unfounded by the OSC, and the agency has recognized that. OPR had produced an inaccurate bias report in an attempt to terminate my employment and remained in contact with the same chain of command who had shut down the EB-5 case. This is a direct conflict of interest. The 2011 complaint was used after the agency was unable to substantiate any allegations against me and as a tool to ensure that I OIG or continue the investigation into the EB-5 program. There are no policies in place which limit the disciplinary actions against agents. Agents are placed on administrative restrictions for years at a time, which is a gross mismanagement and a waste when these agents are needed to support cases and protect the U.S. I was slandered to the point that I couldn't perform my job because of the malicious and false gossip. took away the time and happiness from my family, and I'm still currently being held hostage by my own agency. It's demoralizing to myself and agents to have directors and senior leaderships bury their heads in the sand and ignore the reports of undue influence and surveys that clearly identify agents wanting to do their jobs but being unable to because of the leadership. It condones and it encourages bad behavior within the Department of Homeland Security. I'm here to inform the committee at an agent level of the retaliations surrounding one of the largest investigative branches of the federal government. Agents and officers need to be valued by management, not punished, when they disclose factual and important information to our leadership. In closing, it's important to have agents at your front line coming forward on issues that affect the safety of our nation. To this committee, I look forward to listening to your insight and answering any questions you may have. Thank you, sir.
Thank you, Ms. Johnson. Our next witness is Mr. Michael Keegan. Mr. Keegan is a retired Associate Commissioner for Facilities and Supply Management at the Social Security Administration. Mr. Keegan has raised concerns about waste within the Social Security Administration. Mr. Keegan.
Chairman Johnson, Ranking Member Carper, and distinguished members of this committee, thank you for this opportunity to discuss my demotion, reassignment, and retaliation during my tenure at the Social Security Administration, or SSA. In July 2011, I was recruited by former Deputy Commissioner Budget, Finance, and Management, Michael Gallagher, specifically to assume management and responsibility for the Office of Facilities and Supply Management, known as OFSM, an organization of approximately 500 employees and contractors operating and administering management and real estate actions for hundreds of SSA facilities across our country. In January 2012, I was assigned as the project executive for the construction of a replacement computer data center. This project was funded via a $500 million appropriation as part of the American Reinvestment and Recovery Initiative. Congress had been briefed by SSA officials that the appropriation was needed to replace the existing National Computing Center, or NCC, located on the SSA headquarters in Woodlawn, Maryland. Most notably, the replacement data center occupied only one floor of the entire National Computing Center with approximately 75 employees. However, an additional 925 employees work in the building's other 3 floors. The centerpiece of the justification presented to Congress was that the NCC was beyond economical repair, in terrible condition, and had to be replaced in totality. My duties further required attendance at quarterly congressional staff meetings before the House Ways and Means Subcommittee on Social Security. SSA was required to brief the committee on the progress and costs of the NCC replacement project. I was an important member of SSA's delegation. In the course of performing these duties, I discovered a number of serious problems at SSA. I first brought these problems to the attention of Assistant Deputy Commissioner Budget, Finance, and Management, Ms. Tina Waddell, who did not act on my recommendations and instead instructed me to brief the new incoming Deputy Commissioner of Budget, Finance, Management. In February 2013, Mr. Peter Spencer was brought out of retirement by Acting Commissioner Carolyn Colvin to assume the duties of Deputy Commissioner. Soon after Mr. Spencer's arrival, I gave him a detailed briefing on serious issues that I believed included misleading Congress, waste and abuse. I further raised employee overtime and travel abuse issues. However, the most significant issues I raised involved SSA's representations to Congress to replace the entire National Computing Center, when at most only the part of the NCC that held SSA's data center needed replacement. As an example of this lack of candor, testimony on the record from Patrick O'Carroll, SSA's Inspector General, references the National Computing Center replacement with the National Support Center data center. Page 3 of that testimony notes that SSA represented it was monitoring and improving NCC plumbing conditions, foundations, and monitoring HVAC ductwork as examples. This was no mistake or misunderstanding. SSA was specifically advised by an independent assessor to revise a Jacobs engineering report to directly address the committee's inquiries on construction costs and future use of the NCC. SSA refused to follow this recommendation and chose not to be forthright with Congress. And further, there was no mistake. At depositions, my attorney specifically asked and clarified from Ms. Colvin and her top aides that SSA never had any plans to replace all 4 floors or the entire National Computer Center. Attached for the committee's review are Exhibits 5 through 7, deposition transcripts, which demonstrate this lack of candor. I asked the committee to pay special attention to Ms. Colvin's deposition transcript, where she denies knowledge of that which National Computing Center employees do, where she testifies that she never saw the reassignment letter that ruined my career, a letter which she signed. Notably, her testimony that her chief of staff made the critical decisions against me, which was squarely contradicted by her chief of staff's testimony, which stated she made those decisions. I asked the committee to read pages 41 to 46 of Mr. Spencer's testimony as an exhibit, in which he dances around basic questions about whether he would consider purposely misleading Congress to be unethical. Mr. Spencer actually testified that he could not affirmatively say that purposely misleading Congress is necessarily unethical. Shortly after my report to Mr. Spencer, I was removed from the quarterly congressional staff briefings. A week later, a formal investigation was launched against me. Although I was cleared from the completely fabricated discrimination and hostile work environment allegations, I was removed from my position and left to languish in an empty office with a few tasks that a junior administrative employee could complete. To this day, after 22,000 pages have been turned over by SSA and Discovery and 10 depositions by my attorneys, nothing has been shown by SSA that I deserve this retaliation. In July 2014, after blowing the whistle again on Ms. Colvin for misrepresenting to Congress the success of a $300 million disability case processing computer system, I finally made the very difficult decision to retire from government service 5 years earlier than planned, which has caused me significant hardship. I'd be pleased to answer any questions that the committee may have for me. Thank you.
Thank you, Mr. Keegan. Our next witness is Jose Ducos-Bello. Mr. Ducos-Bello is a chief officer with the U.S. Customs and Border Protection in Washington, D.C. Officer Ducos-Bello has raised concerns about overtime abuse at the Customs and Border Protection to the Office of Special Counsel. Mr. Ducos-Bello.
Good morning to all. Chairman Johnson, Ranking Member Carper, and members of the committee, thank you for inviting me to appear before you today to help you blow the whistle on retaliation. I am a former member of the United States Army Aviation, and I served with dignity and honor for over 6 years until honorable discharge, because during a military operation in 1993, I suffered a severe injury which incapacitated me to perform my duties for 60% of my physical ability to continue flying. Of my duties, after my recuperation, I decided that I would like to continue serving the government as I dreamed when I was a child, raised in Aguadilla, Puerto Rico, next to the Ramey Air Force Base, where I enjoy watching all those B-52s going into practice during the Cold War. And I say to myself, one day I'm going to be up there. Well, God gave me that opportunity. Moreover, I spent a year in Walter Reed in a body cast, recuperating from my injuries. And with the help of my wife and the physical therapist, I started walking again. And I've proven testimony that to this day I can do law enforcement work with all my pains and aches. When I was early discharged in 1995, I immediately took a position as a U.S. Customs Inspector in San Juan, Puerto Rico, where I made a lot of good things for this nation, and I continue serving with pride, honor, and dignity to this day. When I joined in 95, I completed to this day 20 years of active service with the service that is now the Department of Homeland Security, U.S. Customs and Border Protection. Sadly, because I did the right thing, I have suffered retaliation from the people that I would have expected to receive support and complete admiration for doing the honorable thing. Because I remember back in 1986, as I did just now when I raised my hand and swear to tell the truth, I also swear to protect the Constitution of the United States against all foreign and domestic enemies. Well, members of the committee, we are dealing right now with domestic enemies. Enemies that have no intention of respecting the Whistleblower Act and protect the people that do the right thing by reporting wrongdoing in the government. I reported the fraud, waste, abuse, and abuse of authority of more than $1.5 billion of taxpayers' money. And all of us on here are taxpayers. And I am an American citizen, and I'm proud of that. And I'm also proud of serving this nation as a public servant. All of us are public servants. We are not entitled to anything but to do our job for future generations so that this nation prosper and continue for many years to come. We don't want to see the United States end burned up like Rome did hundreds of years ago. I don't want to say that I am swinging for Republicans or for Democrats. That's not the issue at stake over here. This is bipartisan. And my duty from the moment I got this badge and a weapon to fight for America in a war and two conflicts is to defend the Constitution of the United States and to kiss all glory every time I can. Because that's my pride. That's my legacy to my children. If I'm here, it's for a reason, to leave a legacy to my children. And as Senator Carper was saying earlier, we have to protect the way that we spend federal funding. Nobody is entitled to say, well, forget about it, it's the government money. No, it's my money, it's your money. Every time you file taxes every year, it's your money. I have to say that CBP should avoid right now wars that they cannot win, and never raise your flag for an asinine cause like fraud and corruption. I have been made the villain, the black sheep, the inconvenient truth to the Department of Homeland Security, and that has to stop. I know we have many provisions in our system to protect whistleblowers, but the agencies, they don't care, and they try to cover it up as much as I can. My situation is well known. I have been suffering. I lost my job at the Commissioner Situation Room. I cannot go back, and gladly, with the help of the Senate and the Office of the Special Counsel, I am getting there. I'm going to get my job back, even if it is the last thing I do, because I worked there for 11 years and I never did anything wrong to deserve what is coming to me. I also, with the help of this committee and the help of the OSC, I am trying very hard to have the OSC gain more power over their investigation, because the agencies do not respect the way they handle their investigation. And I want to end with a quote that President Obama, our leader in charge of this great nation when he said, democracy must be built through open societies that share information. When there is information, there is enlightenment. When there is a debate, there are solutions. When there is no sharing of power, no rule of law, no accountability, there is abuse, corruption, subjugation, and indignity. I have been called many things. People laugh about my accent in Spanish. People might say that I'm a colorful character. People may think that I am just a second-class citizen. And I remember Senator John McCain telling me, if you are, Mr. Ducos, a second-class citizen because you were born in Puerto Rico, then I'm riding the bus with you because I was born in Panama. There is no place in our government, in our society, to reprise, to discriminate against people that do the right thing. I am one against many, and look what I did. I'm still standing, I'm still here, I have a job. And I want to do my job with your help. Also, I would like to cite something that helps me go by every day. Honor is simply the morality of superior man. Believe that you can do something and you're halfway there. And like Theodore Roosevelt said, speak softly and carry a big stick. So, in conclusion, and let me find my paper. I have everything in order here. My professional reputation has been tarnished in public and social media, and my family has suffered the ill effects to my well-being. These are the facts and the evidence that I have provided to the staff of the committee. It will be much, much, much more. I will never do my 6 minutes if I tell you all the retaliation things that my agency have done to me. It's in writing and is accessible to you as evidence. But more now than ever, I will ensure that all federal employees feel secure to report acts of corruption, waste, or security concerns that can bring grave danger to our national security. When it comes to federal agencies committing acts of wrongdoing, we are not scoundrels. We are the undercover cops on the lookout to prevent Uncle Sam from being pickpocketed. Thank you very much, and I'm looking forward to answer any questions that you may have for me.
Thank you, Mr. Ducos-Bello. Thank you for your testimony, for your service to this nation, for your patriotism. I don't think there's anybody in this room that doesn't think you're anything but a first-class citizen. Our next witness is Mr. Tom Devine. Mr. Devine is a legal director of the Government Accountability Project, a nonprofit, nonpartisan public interest organization that assists whistleblowers. Mr. Devine.
Thank you. The testimony from the last four witnesses personifies why I've spent the last 35 years working at GAP instead of getting a real job. And today's hearing is welcome, much needed oversight for the marathon struggle to turn paper rights into reality. Working with over 6,000 whistleblowers since 1979, one of the primary lessons that I've learned is that passing these laws is just the first step on a very long journey. And today's witnesses did just a great job of sharing lessons learned based on their personal experiences. I'd like to extend that to the bigger picture. And the first lesson to be shared is one that I think is pretty obvious, that whistleblowing through Congress can have the greatest impact, making a difference against abuses of power that betray the public trust. In our experience, no other audience comes close. But correspondingly, the second lesson is this makes Congress the highest risk audience for whistleblowers. And that's because there's a direct linear relationship between the severity of the threat posed by a disclosure and the viciousness of retaliation. Since Congress has more impact, it's higher stakes in both directions. The third lesson is that retaliation doesn't end. After blowing the whistle, employees face often a lifelong struggle for professional survival. This is a life's crossroads decision. The fourth lesson that I think is worth sharing is that since the WPEA was passed, creative harassment tactics are circumventing its mandate. These are very serious challenges. The most all-encompassing is the sensitive jobs loophole. This is a national security loophole that would subsume the entire civil service rule of law that's kept the federal labor force nonpartisan and professional since 1883. There's been no empirical studies or basis for scrapping the civil service system. There's no structure in place for a government-wide replacement or alternative to it. But the Federal Circuit Court of Appeals, the same court that forced passage of the WPEA, has approved it. Last Friday, the Office of Personnel Management issued final regulations. It is full steam ahead. Under those rules, the government has uncontrolled power to designate almost any position as national security sensitive. Once that happens, sensitive employees no longer have the right to defend themselves in an independent hearing. They don't even necessarily have the right to know what they were charged with doing wrong in order to lose their designation to work for the federal government. Now, the administration has said, well, we're not attacking the Whistleblower Protection Act, but that's very disingenuous. The agencies will still have the authority to present an unreviewable, independent justification for their actions, even if retaliation is proven, loss of the sensitive job designation. And that means that by definition, every whistleblower will lose a case who has a sensitive job. We can still have the Whistleblower Protection Act. It will give you the right to lose and turn the WPEA into a bad joke. Unless Congress acts, we're on the verge of replacing the rule of law with a national security spoils system, and taxpayers will be the big losers. The second creative tactic that I'd like to highlight is criminalizing whistleblowers. As we've seen from this morning's testimony, a new tactic is instead of just trying to fire someone, put them under criminal investigation and then give them the choice of either resigning or facing a prosecutive referral. This is very attractive. It's much easier, much less muss and fuss than litigation. You have to prepare formal charges and depositions and legal briefs and hearings and lawyers. All you need is one good investigative bully. Second, you can't lose. The worst that will happen is the agency will have to close the case. And then next month they can open up a new case on a new pretext. I had one whistleblower who faced 30 years of serial criminal investigations. He was fighting bribery in the Chicago meat yards. The third factor is the chilling effect of facing jail time is much more severe than the chilling effect from possible loss of your job. The fifth lesson learned is that the Whistleblower Protection Act is a work in progress. The two most significant structural reforms for the Act to achieve its premise have not yet been finalized. GAO must recommend whether, like almost every other group of employees in the U.S. labor force, federal government whistleblowers will be able to enforce their rights through district court jury trials if they don't get a timely administrative ruling, and normal access to appeals courts. The All Circuits review provision of the WPEA is just an experiment. Senators, these are the structural cornerstones for the WPEA to work. The GAO report is due in a year and a half, and it's time for them to get started on it. The sixth lesson learned is that we're overdue reauthorizing on oversight and reauthorizing of the merit system agencies that implement the WPEA, the Office of Special Counsel and the MSPB. The good news is that the leaders of these two agencies have really an unquestionable commitment to the merit system in their agency missions. It would be silly to challenge their good faith. And in both agencies, their performance is probably the highest in the history since they've been created in 1978. The bad news is this is a very low bar. At the MSPB, while the full board has been very even-handed, the administrative judges are still extremely hostile to the Whistleblower Protection Act. I can't honestly tell employees that they have a fair chance at justice doing an MSPB hearing. And at the Office of Special Counsel, despite a 600% increase in corrective actions, that's brought us up to 2.6% of people who file complaints there. Which means that although they're doing a lot better, whistleblowers still don't have a fighting chance at justice when they try to act on their rights under this law. The bottom line, the WPEA was a great first step. The commitment of the agency leaders charged with enforcing it is an outstanding second step. But we've got a long way to go before we achieve the Act's purposes. There's a lot of work. And thanks for holding this hearing to help us get started.
Thank you, Mr. Devine, for your testimony. Let me start by saying, as I was reading the testimony, as I'm listening to it, coming from the private sector, where when you're at the top of a company, it's always kind of hard to get the information not filtered so that you really get the truth. I mean, as I'm hearing what was brought to the attention of superiors, I'm thinking you ought to be having medals pinned to your chest, not have retaliation inflicted upon you. So what I'd like to ask the whistleblowers here, I want you to very, hopefully as easily as possible, describe to me why. Why were you retaliated against? And I'd like to start with Lieutenant Colonel Amerine. And I appreciate you meeting with me in my office yesterday. I just want to, because you told me an awful lot yesterday, which I appreciate. I think I maybe have your why, but I want you to confirm this. You told me that in the course of your attempts to gain the freedom of these hostages in Afghanistan and Pakistan, you were made aware, it's your belief, that the government did pay a ransom and that ransom money was stolen. And secondly, that you believed you were pretty close to potentially having a deal where we would get 7 hostages in exchange for 1 Taliban leader. And instead we got 1 hostage in exchange for 5 Taliban leaders. Is that kind of in a nutshell, that information, is that why you've been retaliated against, or what is the reason? Yes, sir.
I think that there are layers of this, as I said, in terms of layers of the bureaucracy. On December 1st of 2014, Representative Hunter submitted a complaint to the IG alleging an illegal or questionable ransom possibly being paid for Sergeant Bergdahl. There was a good deal of evidence that it occurred and a lot of questions as to how it occurred. That complaint implicated both the DoD organization and the FBI. So part of what lit the fuse was the same folks in the FBI that were basically implicated in the DoD IG complaint of 1 December were the ones that later complained to the Army that I was sharing sensitive information with Representative Hunter. Another aspect of it on the FBI side was, I think, just the general frustration with Representative Hunter pushing them hard on civilian hostages and their awareness that I was speaking to Representative Hunter about all of this. I mean, he even set up a meeting between my office and the FBI to try to help them out with some of this. And after the meeting, they responded by contacting Caitlin Coleman's father and threatening him not to speak to Representative Hunter again or he would stop getting supported by the FBI. I mean, just an atrocious treatment of family. So the FBI complained to the Army, and for reasons to be seen, there was a bit of a debate within the Army whether I actually did anything wrong. And my understanding is one party, who I just don't want to be speculative, but there was a big debate within the Army over whether I did anything wrong, and that led to the investigation.
Can you tell me a little bit about what deal you thought you had for the release of the hostages?
So my office worked options. We looked at a whole variety of options. One of the options that we developed was a, we called it, the 1 for 7 option. It entailed 6 hostages and a 7th person I'd just rather not discuss today. So the 6 hostages is actually 5 hostages and a prisoner of war. So Sergeant Bergdahl, Caitlin Coleman, the child she bore in captivity, Josh Boyle, and Colin Rutherford. When we saw that nobody else was trying to get them home, we were working every initiative possible. One was the 1 for 7, and in that we were looking at Haji Bashir Norzai. He was described as the Pablo Escobar of Afghanistan, and we realized that he actually was just another warlord who was actually an ally of the Karzai regime. We lured him to the U.S. under a false promise of safe passage and basically unsealed an indictment and put him in jail for life. Some felt he was a wretched human being, and others felt he was wronged. As we looked at the options, we looked at 5 for 1, which we thought had died in 2012, as the worst option. And so for us it was, we aren't getting Bergdahl, let alone the other hostages, back for free. Every option was going to be painful. So the Norzai option for us was one that was at least less painful. So we were able to reach out to the Norzai tribe itself that we believe could free the hostages, and we made a lot of progress on it. I briefed it widely, but in the end, when the Taliban came to the table, the State Department basically said it must be the 5 for 1. That's the only viable option we have, and that's what we went with.
I can see how members of the government, if there was an option for 7 or 6 Americans for 1 Taliban, and the deal ended up being 5 Taliban for 1 American, they probably wouldn't want that too highly publicized. So, okay, that makes sense to me. Ms. Taylor, can you, again, try and encapsulate it pretty concisely in terms of why? Who was threatened? What was threatened?
I think with regards to who was involved in the investigation, I'm going to do that every time, sorry guys. I think that because of the people that were involved with the investigation, it maybe put a different light, and there was a lot of extra outside influences and kind of back and forth with the different members and different agencies. So we're all kind of, as police officers, the last thing you want to be is listed as a whistleblower, and you usually ride the wave and keep your head down and your mouth shut. And I actually did that in this case until I was contacted by the Inspector General's office, and we are required to cooperate with them, and I did. And I think breaking that silence kind of, I mean, I had everything in a 12-year career thrown at me, and a lot of stuff that was not factual. So I think there was a lot of issues surrounding that as far as the retaliation. Briefly, because I don't want to lose this thread. You said, as an investigator, the last thing you want to be known as is a whistleblower. Is that because it's well known, the retribution, the retaliation? Well, there's a brotherhood. You don't want to see your colleagues hurt. And in this case, I don't see a lot of corruption or a lot of problems at the agent level. What I have seen is some significant problems at a leadership level. And that's not to get anybody in trouble. I think one family in DHS being hurt is enough. I just think there needs to be some corrective action. And I lost my train of thought. Did that answer your question?
No, it does. Thank you, Ms. Johnson. Senator Carper.
Thanks, Mr. Chairman. Again, our thanks to all of you for being here and for sharing your stories with us. On Veterans Day, I went up and down the state of Delaware. And there are any number of places where we met with veterans, young and old, their families, families of people who died serving our country. And it was just a wonderful uplifting of their service. One of the things that Delaware is noted for, we're the first state to ratify the Constitution. And one of the gatherings that we had was in Dover, Delaware. The Constitution of our country was first ratified in Dover, Delaware, a place called the Golden Fleece Tavern, on December 7th, 1787, over 200-some years ago. And at that particular event, they actually closed down the streets, the main streets in town, and the intersection of State Street and Lockman Street. And we had just hundreds of veterans and their families, like, all in a big circle around the intersection. And we were gathered about 200 yards from where the Golden Fleece Tavern once stood, where the Constitution was first ratified on December 7th, 1787. And I invited the folks who were there that day, as I invited people in other assemblies that day on Veterans Day and Memorial Day. I invited them to join me in doing something that a lot of us did when we were kids in school, and that is to recite the preamble to our Constitution. I didn't expect them to know it verbatim, but I would read a few words and they would repeat them. And till we finished the preamble, we did this up and down the state. I love doing it. I think people enjoyed it as well. But you recall the preamble of our Constitution starts off with these words: "We the people of the United States, in order to form a more perfect union." Think about that. In order to form a more perfect union. It doesn't say in order to form a perfect union, but a more perfect union. And for me, one of my core values, and perhaps one of yours, is everything I do, I know I can do better. And the folks who wrote that Constitution that was ratified on December 7th, 1787, down the street from where we gathered on Memorial Day, they realized it wasn't perfect. And they realized with future generations, we had to do better and better and better. As Mr. Devine notes, we've been working at this for a while with respect to whistleblower protection. My recollection was the Whistleblower Protection Act was first adopted in the 1980s. I don't recall who was president when who signed it into law. Do you recall?
Yes.
Make sure your mic is on.
President Reagan was in office when Congress first passed it, but President Bush was in office when the law was finally signed.
There you go. Thank you. But we've been working on this for a while, and we're working on it in 2012 with the Whistleblower Protection Enhancement Act, which I supported, and a number of us supported, signed into law by our current president. I want to ask you if you would, Mr. Devine, thinking about the enhancements that we adopted in 2012, why they are an improvement over what existed before that, and while there's still more that we need to do, could you just walk us through a few of the more important changes further changes that you believe are needed, and just give us a couple of real-life examples of how those changes would improve whistleblower protections?
Thank you, Senator. I think the most significant are following through and completing the structural reforms that will provide an adequate foundation for these rights to be implemented. Congress had to pass the law 4 times because there was not normal access to appeals court. In the one court that handled all the cases happened to be extremely hostile to the law, and that lack of healthy competition was an Achilles heel. The WPEA structurally solved that for a 5-year experiment in normal access to appeals courts, and that needs to be made permanent. It's the case with every other whistleblower law in the books except the Military Whistleblower Protection Act, which has no judicial review. The second structural reform is if there's not a speedy administrative ruling, like all the corporate whistleblower statutes, being able to start fresh then in court and have justice determined by a jury of the citizens that whistleblowers are purporting to defend when they risk their careers. This district court access is particularly significant. Get the politics out of these cases when it's a politically charged dispute or an extremely high stakes one, or when is highly complex or technical, and you need the resources of the district court. The MSPB was set up to resolve office disputes, not to deal with major issues of national policy. With respect to the administrative agencies, I think that there needs to be some very intensive training of the administrative judges at the Merit Systems Protection Board. The No Fear Act says that we have to train all the government managers and bureaucrats in what their rights are in these laws. The people who are conducting the hearings, in the administrative hearings, they need to get up to speed on this law too. Unfortunately, the decisions have been very, very uneven. At the U.S. Office of Special Counsel, I think that the area that Congress could, besides just oversight, which is always healthy, the area where Congress could make the most difference is by giving them the authority to issue stays or temporary relief. In my experience, the most significant factor, whether we have sort of a long-term marathon nightmare or whether the agencies decide to get serious and have a resolution that both sides can live with and move on from, is whether there's temporary relief. If there's not, the agencies just starve out the whistleblower. That'll make a huge difference. Finally, those issues of the national security loophole in retaliatory investigations, which threatened every witness this morning, but for which they have very uncertain rights under the WPA. That's sort of the menu of work to be done.
All right, thanks for all of that. Several of you today are wearing uniforms. Others have worn them. Some Army, Navy. And Mr. Ducos, what branch of service did you serve in?
My branch of service is the Department of Homeland Security. The component is U.S. Custom and Border Protection.
Now, when you're on active duty with the military, I thought I understood you say that you served on active duty.
Yes, United States Army Aviation.
Good things. I spent 5 years in a hot war in Southeast Asia and another 18 years in a Cold War as a naval flight officer on active duty and later reserve duty, retired Navy captain, commander-in-chief of the Delaware National Guard for 8 years when I was governor. And I have huge respect for you, particularly those of you who wore those uniforms. And thank you for your service in that regard.
Thank you, sir. And the slogan back then really helped me a lot. Be all you can be.
Oh, that's good. That's good. Mr. Devine, just take a minute and tell us, not just a minute, tell us what, with respect to how we treat whistleblowers who are civilians as opposed to those who are military personnel. Just give us a minute on how, since we have both civilian and military personnel on our panels today, and I know you work with both, can you just briefly discuss the differences between whistleblower protections for the two, just briefly?
Yes, sir. The Military Whistleblower Protection Act is the lowest common denominator in the U.S. Code for accountability through whistleblower protection. The key differences between the civilian and military law is, first, that the military law does not have the fair burdens of proof that have given whistleblowers a fighting chance in their hearings. The second is that there's no right to an administrative due process hearing. Everything is enforced by the Department of Defense Office of Inspector General. GAO has repeatedly condemned their work as inadequate, and at GAP we get numerous whistleblowers from that unit whose disclosures are that it's operating as a plumber's unit to help finish off the people who seek help there. It's a very severe problem. We need due process. And finally, there's no judicial review there. There is some outstanding legislation, which is the Service Members Justice Act, which has been introduced by Senator Boxer, joined by Senator Grassley, and vetted by all the whistleblower support organizations that could even the playing field. And we think that it's outstanding.
Good. Mr. Johnson, Mr. Devine just mentioned Senator Grassley's name, and I would just share, Mr. Johnson, this is really pertinent to what you said earlier. For years, the Department of Homeland Security has called on the Congress to make changes in the EB-5 program, a well-intended program, but a flawed program. And earlier this month, Senator Grassley and Senator Leahy have introduced legislation that actually reflects the changes that the department and the agency has actually been asking us to do, so I'm encouraged by that.
I saw that, sir. I think that's great.
Yeah, thank you.
Thanks, Senator Carper. Our next is Senator Ernst, because she's almost always here on time, probably always on time, and a very faithful attendee of these hearings, which I truly appreciate. So, Senator Ernst.
Thank you, Mr. Chair. Thank you, Senator Carper, Ranking Member. Ladies and gentlemen, thank you all for being here today. I appreciate it so much. And Colonel Amerine, am I pronouncing that correctly? Colonel Amerine. I do want to take just a moment and thank you very much for your service to this nation and to all of you as well. But you have been in some very difficult circumstances, and I do appreciate you being here today. As someone who has served, I do take this very seriously in my new role as a senator and as someone who has made a commitment to protect our men and women that serve in the United States Armed Forces, whether they are still serving in uniform or whether they are veterans, eras of the past. So whether it's through proper medical care, whether it's through the VA, and whether it's in your circumstance, we will make sure that that is a priority. I will take just a little bit of issue with your testimony. In here, sir, you say you have failed, and you have not failed. I will never accept that, because what you have done is raise an issue that is extremely important to this nation and in making sure that we receive those hostages back. So you have not failed. We have just not yet succeeded. So that day will come. We will make sure that that day comes. So to you, thank you so much for all of your efforts, and we will continue working on this. I look forward to working with you, Senator Johnson, on some of these very specific issues, especially with the good colonel. To the rest of you, I do want to ask very briefly, my time is very limited here today, but those of you, I know you have recent cases, but have there been any repercussions for those that have come after you and retaliated against you? Have you seen any correction from that end? If you could just briefly, Mr. Ducos-Bello, if you would please start just very briefly. Have you seen those that retaliated against you being disciplined?
Well, my retaliation started back in the end of 2012. And to this day is ongoing. I was disarmed for no reason, like my fellow law enforcement officer here, illegally. They turned every single stone that they could find during my 20 years career, and they couldn't find anything. My review performance is fully successful throughout the year. I don't have this because somebody gave it to me as a gift. I earned them. This one is the Blue Eagle Award that I received for meticulously searching and researching a container coming from Colombia with 8,000 pounds of cocaine. And when I was in the field, I was very diligent doing and discharging my duties. And I move up the chain of command the right way, not by making a network of friends, but by earning my rank, my position. And to this day, the agency is treating me with no respect. For the past 6 months, I have been sitting in a folding chair with no desk, no duties, no program to manage, nothing. I just show my face for 8 hours, and all my talents are going to waste.
But no correction on those that retaliated.
They are fixated in that they haven't done anything wrong, that as a whistleblower, I committed the worst crime to CBP by taking the AUO away from the Border Patrol, and the CBP officers that changed their series from 1895 to 1801 in order for them to be seduced by the Border Patrol in drawing that AUO with is illegal. Now, you tell me, I am in 1895, abide by the Constitution to obey and discharge the law. How come in less than an hour in the Library of Congress, I came upon the the regulations and the law that governs the use of AUO. And for those who don't know what AUO means, is the uncontrollable overtime that they draw out of 20%, 25% of their yearly salary.
And thank you. I would like to go ahead and move to just very briefly to some of the other members on our panel. Thank
Yes,
you
ma'am. You're
very
welcome.
much for being here today. Mr. Keegan?
Thank you, Senator. I have absolutely no knowledge that there's been any accountability repercussion in any way involving senior leadership. Senior leadership at the Social Security Administration, and I can very quickly characterize this in two areas. If you recall from my testimony, I testified that my supervisor, Mr. Spencer, actually testified at deposition under oath that he could not uncategorically agree that misrepresenting facts to Congress was not ethical. The second thing I would tell you is that there is a mentality at the Social Security Administration, which I witnessed in many senior level meetings, concerning bad information stays in the House. We do not air our dirty laundry to Congress. We protect our leadership at all costs. And third, I would just say, in my 44-year career in the military, private sector, and as a senior executive of 4 agencies, the Social Security Administration has the worst track record of accountability and taking responsibility for their actions that I have ever seen. And I do not mean that in a flippant manner, Senator, but I mean that sincerely.
No, thank you. And Ms. Johnson?
I'll keep mine very short. There's been no corrective action.
Okay, I appreciate that. And Colonel Amerine, yours is a very special case. Any specifics that you would like us to know?
No, ma'am.
Okay. Thank you very much for your testimony today. Thank you, Mr. Chair.
Thank you, Senator Ernst. Senator Portman.
Thank you to Chairman Johnson and Ranking Member Carper for having the hearing, and mostly to thank you all for being here and being willing to share your sometimes very personal experiences and troubling experiences. I saw Mr. Devine's testimony before I came in today, and he repeated it in his remarks. He said this is one of your highest risk audiences. So I hope that at the end of the day, you're happy you shared this information with us, and we don't end up being a high risk to you for speaking to the United States Congress, your elected representatives, because we need the information. And, this committee in particular is an oversight committee, so our job is to ensure the federal government works better for all the taxpayers, hardworking taxpayers out there that we represent. So it's really important you're here today to talk about the broader policy issues as you have, but also to put some context around it. What really happened to you, and to your responses a moment ago as to, from Senator Ernst, as to what actually has happened that's changed in the departments. It's discouraging. I do think, Ms. Johnson, that the legislation that you mentioned earlier, affirmatively, you said that was a good idea to move forward on some reforms, indicates that maybe Congress is able to move on some legislative changes. And I want to talk about that for a second, if I could, and maybe start with the military side. There's been some discussion, Mr. Devine was asked, about the military whistleblower protections versus other departments and agencies. He said it was the lowest common denominator. He talked about no judicial review. He talked about the burden of proof is the lowest common denominator. He was concerned about lack of a due process hearing. One of my concerns is about what the GAO has said. And as you know, in May of this year, they issued a report, and it was about investigations into retaliation complaints from military whistleblowers. It said they took 3 times longer than the legal requirement of 180 days. So that alone, seems to me, indicates that we've got a problem on the military side. It also talked about the chain of command issue, that service members are required to report wrongdoing outside the chain of command, but that conflicts with other military guidance, and that sometimes that's very difficult, therefore, to go outside the chain of command and to have an independent process. And so I guess, if I could, Colonel Amerine, to you, the IG responded to the GAO report by saying that they concurred with the recommendation and they were committed to, and I quote, requiring service investigators to attest in writing that they are outside the immediate chain of command of both the service member submitting the allegation and the individual or individuals alleged to have taken retaliatory action. Is this attestation requirement for whistleblower investigations sufficient to ensure independence from the chain of command, in your view?
I believe it is. I mean, the DOD IG has a very difficult job, and their treatment of me as I filed a whistleblower retaliation complaint with them was first class. It is a slow process, but I haven't hit the 180 days yet. I mean, so the investigation is ongoing, and they're working it as hard as they can.
Well, I'm glad to hear that in your case. And in terms of the complaints that have taken almost 3 times longer than the legal requirement of 180 days we talked about, why do you think that is? And what should the IG do to respond to that, or what should we be doing legislatively in terms of the overall structure of the military side of whistleblower retaliation?
Yes, sir. I mean, some of that is beyond anything I'd claim expertise in, so I have to, kind of scope it down to what I'm seeing. I mean, in my case, I had a retirement date of June 1st that everybody was aware of. The DOD IG reviewed my complaint that included the information that supposedly was a security violation of Representative Hunter, and through the Joint Staff, the DOD IG determined that my complaint was not classified, which would pretty much mean the information I spoke to Hunter about, which by design was meant to be unclassified, was actually unclassified.
And it was the FBI that had said that they thought it was classified, correct?
Right. The FBI filed the complaint, and even in a session with Representative Hunter, basically said that, we had to put him in his place. I mean, they felt that it was one of those things where it was a shot across the bow. Well, they did that with a criminal allegation. So they kind of underestimated the effect of telling the Army that I'm leaking secret information, and that led to, the situation I'm in right now. I mean, on the positive side, the calamity allowed me to share with you aspects of the broader dysfunction I was dealing with. But in terms of resolving this, it should have been resolved with a simple conversation. Before the FBI complaint even hit, I notified my chain of command what was coming, and they told me, yeah, you did nothing wrong. And then somebody more senior, for unknown reasons to me, demanded this be thoroughly investigated. Okay, that's fine, but in 5 months, nobody has spoken to me about what actually occurred. And that's where I think you run into the issue is the only organization that, to me, has actually kind of effectively grinded through this so far is DOD IG. I mean, everything they did, I felt was first class, regardless of how they ultimately conclude this in the end. But them getting out to interview everybody involved is very, very difficult because they'll approach someone, and in the interview, who's going to incriminate themselves? So, I mean, I think the DOD IG just has an enormously difficult task, and the timelines are the things that, really they have to be enforced. 180 days is actually kind of hell for somebody trying to retire from the military and start a new career, but from what I've seen, I understand why it is 180 days. But the chain of command on top of that needs to have a role in this where I don't understand why when the Army heard that there's an allegation of me speaking to Representative Hunter, they didn't think that maybe they ought to dig into it a bit before they started criminal charges. And when they deleted my retirement, they can only do that with an eye towards court-martial. So basically all I could take away from this is they are seeking to court-martial me under allegations of sharing sensitive information with a representative on the House Armed Services Committee. I mean, it's utterly ridiculous in my mind, but obviously I'm the criminal in this case. So to me, the chain of command really should have stepped up and realized that they needed to handle this a little bit more smartly than basically going after me with CID investigation.
And had a conversation with you at the outset, which you indicate they didn't have. They didn't ask you. Is that accurate?
My chain of command never spoke to me. All I got, the only time I've spoken to is on January 15th when this began, when I was told that I'd be escorted out of the Pentagon because I'm under criminal investigation.
Well, thank you, Colonel. We've discussed today the IGs. We've also discussed the Office of Special Counsel, and I have very little time remaining, but just quickly, maybe Ms. Johnson, you could talk to us about your experience. Has the Inspector General been responsive to your concerns?
Yes, they have. Two investigations have been open. Not really at liberty to talk about that, but they were able to open an investigation into the personnel actions in the whistleblowing complaint, in addition to some other investigations related to that criminal investigation. They have a lot more authority as far as subpoena powers than I think the OSC. I know in my case, the OSC had a really tough time getting my agency to kind of cooperate with the documents, giving them what would make them look good versus what was actually requested. The OPR system for us, at least at the DHS level, was awful. It's my opinion that needs to be made a permanent 14. In SAC LA, the ASACs, the RAC, and the SAC are all agents from Los Angeles under SAC Los Angeles. So for me, going through that OPR process on the numerous allegations that came up after the CB5 and during, it was an awful process. It was the SAC communicating back and forth. But the OSC was eventually good at finding that, and so was the OIG in seeing the communications and the conflict of interest. But the IG was probably above and beyond the best one so far as investigating.
So OSC was helpful in trying to figure it out, but they didn't have you mentioned the subpoena powers, they didn't have the authority to get the information on a timely basis, whereas the IG was able to be a little more effective.
Right, they kept running into walls.
Yeah. Well, my time's expired. Thank you very much, Mr. Chairman, and appreciate again all you all being here and being willing to testify before us today.
Thank you, sir.
Thank you, Senator Portman. Mr. Devine, in your testimony, again, I was looking at these laws ahead of time, and for me it started back in 1978, and I guess it is with the Civil Service Act. But in your testimony, you enlightened me that, no, it really started with the Lloyd-La Follette Act in 1912. And you said it was an anti-retaliation law that created a no-exceptions right to communicate with Congress.
Yes,
Which is
sir.
really the point we're talking about here with Lieutenant Colonel Amerine. He has an absolute no-exception right to communicate with Congress. What's gone haywire? And in particular, the question I asked earlier is, I keep asking myself why. Again, coming from the private sector, I'm always, especially at the top of the organization, I'm always looking for individuals to let me know what's pulling off so I can actually address problems. So again, we should be pinning medals on these people's chest as opposed to retaliating them. So tell me a little bit about that Lloyd-La Follette law. But also, is there some very common, very universal answer to the question, why?
The Lloyd-La Follette Act is an excellent principle, but it's hampered because there is no procedure to enforce it, and there is no remedies even if you found a violation somehow. So it's just basically a symbolic law, and it's been waiting a long time to get some teeth in it. As far as the more fundamental question, I've asked myself that for a long time, Senator, and I think my own insights are that the federal agencies and some private organizations too behave this way almost as the institutional equivalent of an animal instinct. An animal's instinct is to destroy anything that threatens it. And organizations behave the same way. In fact, I do. When somebody slugs me, I don't think, maybe there's a lesson to be learned from that and we should talk this through. What's the cause of it? I want to flatten that person who attacked me because I'm angry, they hurt me, and because I don't want to give them a chance to do it again. And this is the way institutions react to whistleblowers, snuff out the threat, and it's unfortunate. It's very short-sighted. whistleblowers are like the bitter pill that keeps you out of the hospital. It's bad news in the short term, but it can be important for your survival. We've got a whole cliche on it: don't kill the messenger.
Again, that's awful general. As I listen to the four witnesses here, in my mind, I can at least assume some specific whys. Somebody being protected, some piece of information that we didn't want to have disclosed, like for Lieutenant Colonel Amerine, the fact that there really was potentially a deal of 7 Americans for 1 Taliban, that there might have been a ransom paid that was stolen. And I'm going to get back to the other witnesses to find out their specific why, but I mean, isn't it? Again, I'm looking for your knowledge because you've been dealing with this a long time. Is it protecting an individual or people in power?
Part of it is the structure of the communications. When a whistleblower works up through the organizational chain of command, sooner or later you reach someone who's maybe is responsible for the wrongdoing, and a conflict of interest kicks in by someone who has power over the messenger. And that's why it's so important that when there is that conflict, when it's not just a mistake that everybody wants to fix, but somebody's engaged in wrongdoing, that they have access to safe, clear access to Congress to circumvent the conflict of interest and get some independent response to their concerns.
Well, again, that's why we set up our whistleblower at ronjohnson.senate.gov. Just throw that plug out there. And of course, I'm assuming the 4 individuals here will have some measure of protection by coming public and showing courage. Mr. Keegan, I'd like to get, kind of pick up with you specifically. Again, can you point to a why? And then I'm going to ask the other whistleblowers, what does it cost you? I understand in terms of this kind of retaliation, there's reputational harm. That's a cost. It's a grave cost. Having a hostile work environment in all kinds of ways, sitting on a folding chair, not having a desk. All those types of things, but I want the dollar cost. I really want you to let us know how has this cost you financially. But first, Mr. Keegan, I want to give you the opportunity of why, in your case.
Why I think it was done?
Yeah. I mean, was somebody trying to protect themselves? I mean, was it just this general overall, we want to protect the Social Security Administration?
Well, I believe, Senator, having sat in a number of high-level meetings at Social Security in the months prior to this debacle that happened to me, Acting Commissioner Colvin was in the beginning stages of believing she was going to be nominated and then finally being nominated. In at least 3 meetings, the Chief of Staff, James Kisko, was Ms. Colvin's number 2 person, made the statement that nothing is going to leave this agency that is going to embarrass Carolyn Colvin. I can't make a direct connection between that and what happened to me, but it certainly seems to make some sense to me. In answer to your question of what it cost me, I had a 44-year career military, 12 years in the private sector, and 12 years of senior executive service. I had nothing but outstanding performance ratings, awards, and promotions until my very last performance review at the Social Security Administration, which capped off my 44 years and basically destroyed everything that I had worked for in my career. It cost me, practically cost me my marriage, to be perfectly frank, because 1 year of sitting in an office, staring at 4 walls and watching the clock tick, being a very high-energy, results-oriented person, for me was a death by 1,000 cuts. What it cost me financially, I finally just could not take it anymore and I retired. I retired 5 years early. I was not financially prepared to retire, and I have not been able to get a job consistent with my background and my experience for 2 reasons. One, I can't get a reference, and number 2, how do I explain on a resume how I went from a senior member of the senior executive service to a non-supervisory advisor with no responsibility, no accountability, and no duties? Mm-hmm. So I think the cost, and I think my wife would tell you, Senator, the cost has been inordinate and enormous.
Okay, thank you. Mr. Ducos-Bello.
Thank you. For me, the biggest cost has been watching my son trying to jump out of his high school roof because he saw his father lost his uniform, his weapon. He's always been very proud of my career and the way I perform my duties, not only at work, but off duty. I have raised 3 excellent children, but it was the most costing and emotionally devastating thing that I had to do. Receive that phone call that no father wants to receive, that your son is in the roof of his high school getting ready to jump because his father is going through a whistleblower retaliation action. Luckily, I was there. I got in time. The police was there, and the fire department was there with the jumping blanket. He finally jumped, and he was hauled by Montgomery County Police, and he wouldn't let nobody arrest him. He has to be arrested by his father. And with great pain, I picked my son, who is autistic, took him down to the office, put the handcuffs on him, and took him to the patrol. And then I followed on my vehicle and spent 2 days in the hospital talking to him that my problem was going to be resolved eventually, that patient will pay off. Financially, it has cost me over $41,000 in lawyers' fees just to keep my job. I'm in debt up to my neck, but as a responsible citizen, I pay all of them and waiting, hopefully, that one day I can be compensated for all the troubles that financially I have put myself into because I did the right thing. This is very hard for me. I mean, I'm reliving something that no father wants to relive, but it has put a strain, like Mr. Keegan said, put a big strain on my 26-year marriage. But luckily for me, I have a very supporting wife that I can talk to. I used the employee assistance program. I went to therapy and talked to a counselor. And she told me, you know, you haven't done anything wrong. You should be proud of yourself. And why did we create this new enhancement whistleblower protecting act in 2012 if we are not going to clear the air and punish the guilty and protect the whistleblower?
Okay, thank you. Ms. Johnson.
Oh, yes, sir. I think a few things that folks said, just kind of about protecting people in power. The lieutenant here, is it colonel or lieutenant? I'm not military. Lieutenant colonel, I'm sorry. Just having a little bit of common sense and starting a conversation could, you know, there wasn't that communication there. But I think ultimately, as far as reasons, it is protecting people. It's maybe our leadership not having the courage to kind of stand up and say, okay, these are our people, we need to take care of them. It's supposed to be a family. And that's not all their fault. There's been a lot of upheaval with the merger, and, you know, we're all dealing with a number of things.
Okay. Again, I was looking for the cost. I mean,
Oh, I thought you said the cause. I'm sorry.
Oh, I'm sorry, cost.
I apologize. You know, there's always that financial cost with legal fees. You know, I had a great job, so I adopted my 2 little girls. So I have 2 older ones from my first, so I have 4 kids, and I'm in the middle of an adoption. My salary was affected. I didn't get a step increase. So not only did I add 2 kids to my household, but I didn't get my increase. They finally did fix that. But, you know, the phone calls, there's a huge expense just to being an active member of your family. I mean, the joy is kind of like sucked out of your life. I'm pretty fun, and, you know, I like to work hard and go home and play hard, and you lose a little bit of that because it really just sucks it out of you.
Okay, thank you. Lieutenant Colonel.
I mean, for me, I had to burn 2 months of leave that I had intended to use for retirement leave, so that was about $18,000, because initially when my security clearance was suspended, they moved me out of a top secret facility to put me in a secret open storage facility, where my presence in and of itself would have represented a security violation while I'm under investigation for a security violation. So, I mean, I took 2 months leave just to get out of there and to not potentially further incriminate myself. And then thanks to my JAG, Lieutenant Colonel Bill Ruling, I was able to finally get assigned to a position where I wouldn't be, committing a security violation by going to work. There's some legal fees. We'll see how far that goes. But, I mean, the broader cost to me is what it shows the younger soldiers and officers in the Army. I mean, we always have difficulty with our junior officers and our junior non-commissioned officers showing them that, remaining in the military, working your way up the ranks is something you ought to aspire to do. And, I mean, here are all these officers that I knew as cadets that are seeing what's happening to me, and the example set for them is terrible. And what does it do to the Army? The Army is killing itself with things like this. When you go after people who are reporting significant issues and crimes, when you go after people who are whistleblowing, although I still loathe the term, you end up setting a terrible example for all the other people that are seeing the retaliation. So that's the cost to me that matters, is what it's doing to my Army.
Thank you, Lieutenant Colonel. I think that really is, in the end, the final answer of why. Whether it's organization or whether it's protecting somebody else, it's really trying to make an example of somebody so the next person doesn't step forward. Isn't that kind of the bottom line? Senator Carper.
Several of you, again, thank you so much for being here, for sharing your stories with us, and again for your service, past and present, to our country. Several of you said things that reminded me of a sad chapter in our state last week when we buried the son of Joe Biden. And Joe Biden has this saying that I've heard him use any number of times when he's spoken at funerals. And he has said, talking to the family of the deceased, that his hope was that the day would come when the thought of that individual would bring a smile to their face before it brought a tear to their eye. Now, several of you said the word whistleblower is not a term of endearment. And my hope is that you live long enough, and we do too, that just like Vice President Biden talked about the thought of a loved one bringing a smile to the face of the surviving family members, my hope is that in the future, people in our government, in our country, when they hear the term whistleblower, it'll bring a smile to their face before it brings a tear to their eye. So that's one thing. Second thing I want to say, I want to go back to Dover Air Force Base. Dover Air Force Base is one of the finest Air Force bases in the world. Some of you have been there, and they're one of the best, they're maybe the best airlift base we have in the country, in the world. And they had a sacred duty there that involved not so much airlift as it did a mortuary and receiving the bodies, the remains of our fallen heroes. And there were things that were going on in that mortuary that were inappropriate, that were wrong. And there's some of the folks who worked there knew about it and tried to get a change from within, were not successful. And they ended up going on the outside. They came to our office, our Senate office. And we were not sure initially if they're credible, but they won us over. And they convinced us that no, they were there for the right reasons. And the Office of Special Counsel got involved. And I want to tell you, I was impressed. I didn't know, Mr. Devine, going into that, I didn't know a lot about the Office of Special Counsel. But they were like a dog with a bone, trying to make sure that justice was done. And I go to the Air Force Base a lot. It's an important constituent of ours, is our delegation. And one of the last visits I went over to the base last year. I've been there since, but I went back to the mortuary. It's an incredible facility. Some of the hardest work that's done by anybody I've ever served with in the military was the work that folks did there with the remains. If you've ever been there, it's incredible work they do. I applaud them for the work that they do. But some people did not adhere to the high standards that they should have. But I went back to the mortuary last year. And when I walked in, the first couple of people I saw were the whistleblowers. And I looked around to find the full bird colonel who used to run the place, long gone. And I looked around for the civilian personnel who reported to the full bird colonel, long gone. And you know who were running the place? Well, a team that included the whistleblowers. More committed than ever to doing the right thing. The right thing. I want to ask Mr. Devine, I want to ask you to talk a little bit about the entity, council, that actually, special counsel that actually got involved in this case in Dover. I'm sure they're not the only, it's not the only instance where they did the Lord's work and made sure the justice was done. But talk about the work that they do throughout the government. In this case, it was in a military installation. But just talk about the work that they do and how can we help them do a better job.
Well, they've made I think the Office of Special Counsel is probably the best agency in the federal government for whistleblowers to seek justice. So you say it's a low bar, but they're doing their best there. And it's particularly impressive because just 4 years ago they were coming out of chaos where they were subject of FBI raids and the previous special counsel was convicted of criminal misconduct. They've come a long ways. The areas where we're the most impressed with them are their alternative dispute resolution, which is probably the most effective unit in the federal government at making a difference in getting speedy resolution with just results for whistleblowers. They've been very aggressive in using their new authority under the WPEA to file amicus curiae briefs, friend of the court briefs, that have been outstanding. They've increased their corrective actions significantly there. They've overhauled their disclosure unit for whistleblowers to try and make a difference so that it's much more employee-friendly and can hold the agencies accountable for following up and acting on the problems that are confirmed. Those are all very positive developments. We think that they can do better in their complaints examining unit. The quality of the reviews for screening these cases for investigations extremely uneven in my experience in reports that we receive. We think that they need to go for stays, temporary relief more frequently. That's actually been going down slightly in recent years, and that's the single most important factor that there is for whistleblowers to get an acceptable ending. And finally, we think they need to actually litigate some cases. The OSC has told me that, well, the reason they don't litigate is the agencies always surrender whenever they recommend corrective.
Yeah, the agencies what?
They've said that they never really have a chance to go to trial and defeat a retaliation case because the agencies always surrender.
Oh, okay.
I think maybe they're picking the wrong enemies or the wrong issues. I know at GAP we can help them find some whistleblower cases where the agencies will fight back on disputes that make a difference.
All right. A closing thought, if I could. Again, our thanks to each of you for joining us today. And for your service to our country, past and present. I would note, as I did earlier in my my opening statement, I think the chairman did as well. We have before us 5 very impressive people, but missing at the table are those who have another perspective on the stories that you've told. And I think we need to keep that in mind. These are matters that are still being adjudicated, and we'll have to let the process go forward. I'm encouraged by what you said, Mr. Devine, about the changes that flowed from the adoption of the Whistleblower Protection Enhancements Act that we passed in 2012 with my support. I think that might have been before the chairman joined us here, but I'm encouraged that it's working. I I'm also thankful to those of you who turned off your cell phones before. before you came in. The last thing I want to say is this. You all have talked about your core values. I don't know if you knew it or not, but you have. And I have my own. Chairman has his own. Actually, they're pretty similar. And I'll close with these. Number one, figure out the right thing to do. Just do it. Not the easy thing, not the expedient thing. What's the right thing to do? We all need to do that, including the folks that who are running these agencies where you feel that you've not been treated well. The second is golden rule. Treat other people the way we want to be treated. Most important rule of all. And the third, I've referenced it already, and the idea is to focus on excellence in everything we do. If it isn't perfect, make it better. Everything I do, I know I can do better. All these agencies we have throughout federal government, we can do better. We need to focus on, in order to form a more perfect union. And the last one is just don't give up. Just don't give up. You know you're right. You think you're right.
Never.
Just don't give up. Never give up. And I think those are some of the core values that I hear sounded here today. And they're good values for us as individuals, and I think for Congress and for our country. Thank you again. God bless.
Amen.
Thank you, Senator Carper. I'd also like to thank all of our witnesses for your thoughtful testimony, your thoughtful answers to our questions, your courage for coming forward. I want to thank every whistleblower that has the courage to come forward to tell the truth. I agree with the goal of the Lloyd-LaFollette Act, an anti-retaliation law that was created, that created a no-exceptions right to communicate with Congress, which is why we have set up our website, whistleblower at ronjohnson.senate.gov. So again, I want to encourage other individuals of courage to come forward. It's the only way we're going to reform government, reform bureaucracy, is if people know about it, if the public has the light of day shown upon abuse and corruption. So again, thank you all for your testimony, for coming forward. The hearing record will remain open for 15 days until June 26th at 5 p.m. for the submission of statements and questions for the record. This hearing is adjourned.
But I